muted before we get started. Clearly it's not. Here we go.
Brett, are you objecting to the criminal history?
What's that?
I was just asking, Brett, are you objecting to the criminal history?
No.
Okay, I'm filling out the journal entry, so I was just asking.
Oh,
Right. Okay. Let's be on the record. Case number 2019-CR740, captioned in State of Kansas versus Diamond Wilson. Would the parties announce their appearances, please?
State of Kansas appears by and through Assistant District Attorney Garrett Rell.
May it please the court, Ms. Wilson appears in person with counsel Brett Richmond, both via Zoom.
All right. We are here set down for a sentencing today. Back in September of 2019, is that accurate?
Yes.
Okay. September of 2019, the parties appeared in court. At that time, the defendant changed her plea from one of not guilty to guilty. The court inquired and accepted that plea, ordered a pre-sentence investigation, and set it for sentencing today. I've received what has been marked the third amended pre-sentence investigation. And my understanding is there were some corrections that needed to be made, and then the defendant picked up other charges between the time of the plea and today's sentencing, and the PSI had to be amended once again. But I've received the final copy. The critical findings are as follows. The primary count of conviction is interference with a law enforcement officer. That is a severity level 9 non-person felony. The defendant's criminal history score was found to be that of E as in Edward. That would leave her with a presumption of probation and a presumed underlying range of 9, 10, or 11 months. If she has to do that time, she'll be eligible for up to 20% good time credit and subject to 12 months of post-release supervision. If she's granted probation today, it would be for a period of 12 months to court services. That is the sole count of conviction. I would ask you first, Mr. Relf, did you have an opportunity to review this amended PSI? Any additions, corrections, or challenges thereto?
Judge, I have had the opportunity to review the amended PSI. I do not have any challenges or feel the need for any corrections to be made.
All right. Mr. Richmond, same question.
Judge, I have reviewed the PSI as well as the first and the second PSI. The court is correct. Upon Ms. Wilson's release, she unfortunately picked up some new charges and has been sentenced in those in Johnson County. But I will go over that in a moment, though. But I reviewed the PSI with her, and we have no objection or correction to the criminal history score of E, nor the new charges that are in there as convictions.
All right. Ms. Wilson, your lawyer tells me that he went over this PSI with you, specifically that criminal history report, and that you don't have any challenges or disagreements with those findings. Is that correct?
Yes, Judge.
All right, thank you. I will adopt the findings of the PSI for today's hearing. I'll hear your comments upon sentencing, Mr. Relf.
Judge, it's a presumptive probation sentence. I would just ask for the standard sentence of 10 months.
Thank you. Mr. Richmond.
Judge, thank you. Ms. Wilson's unfortunately suffered a little bit of a setback upon picking up these charges with regards to substance abuse issues. She picked up a couple charges in Johnson County and has been basically in custody since that time. Upon her release, Judge, she has an 18-month probation in Johnson County with consecutive counts for backup time, and she is currently going to be released. If she is released from this court, she will go back to Johnson County to the residential center there so she can receive treatment. Judge, I would ask that we follow the plea agreement in this case. And I believe the plea agreement was for the mitigated box. I would ask for that with the probation granted for 12 months. I would ask that it run concurrent with Johnson County. I know this is a little bit different typically about how it can run concurrent or consec. I don't think there's any special rule since this was pled first that would keep it from running concurrent with Johnson County. I would ask that it does. That way, Ms. Wilson can have one supervision together with Johnson County, as Johnson County supervision is going to be for 18 months at this point, Judge. And so I would ask that it run concurrent. I note that I have 67 days of jail credit awarded to Ms. Wilson for time she has served in Wyandotte County for this charge. I would ask that fines and fees be waived in this case. Ms. Wilson indicated to me that she hasn't been working for some time, unfortunately, with her abuse and her substance abuse, as well as her incarceration. And the fact that she is only 20 years old, Judge, and was having some issues of essentially being homeless for a little while as well. Based on that, Judge, I would ask that fines and fees be waived as much as possible. Thank you.
All right. Now, do you have any idea? I mean, I know that she didn't have a sentence in this case yet, but did Johnson County order their sentences to run consecutively, since this was she would have been on bond in this case, which would not have made them mandatorily consecutive, but I know oftentimes they are. Do you have any idea?
Judge, I am looking right now. I just pulled up her case in Johnson County. If you can give me just one moment.
Sure. Did you represent her out there?
I did not, Judge, but I have access to the gyms out there, and I just pulled up the journal entry. Give me one moment.
Sure.
Judge, and she will go to community corrections on this case, even though she'll be transferred to the other jurisdiction.
Being presumptive probation, they never mark that box. I'm interested. Being presumptive probation, they often go to court services. What's the difference here?
Her LSIR score was high, and so that made her go to community corrections.
I see.
Yeah,
Judge,
and that, sorry.
No, Megan, go ahead. Megan, go ahead, please.
I was just gonna say it's on the placement page where they distinguish the two.
Okay.
Judge, I looked it up. They did run it consecutive with Johnson County.
Okay, which doesn't mean her probation is still going to run at the same time. It would only be that if she was to somehow be violated and have to go do her time, that they would be consecutive to this. So I really don't have to address that, because I can't make it non-consecutive, and I can't consecutive to something that's already consecutive anyway. So it is what it is. All right, Ms. Wilson, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
I would just like to say that I know I messed up when you guys put me on bond, but I was going through a rough time with my family, and I was also using drugs, but that's what they're going to give me another chance at the center, and I plan on doing right this time, because I need to get home to my mom, and I want to do better in life. I don't want to end up back here. I'm tired of being in here and being in strikes.
All right. Well, I'm glad to hear you say that, because I look, you're very young. Excuse me one second. You're very young. And I think that helps you in a couple of ways. I think it kind of, if you were 30 years old here sitting in front of me and still doing these kind of things, I would be worried that maybe you would never be able to mature to the point where you wouldn't be dealing with your problems like this. Secondly, I think you have a lot of time to get it straight in plenty of time, so that you can be productive for yourself, for your family, and for all of us, frankly. So I think your youth is something that can serve you well here, but you need to really dedicate yourself to what they're going to be talking about at the residential center, so that when you come out of there, that you're going to be equipped with the things that you need to be successful. Okay.
Okay, thank you, Judge.
You bet. All right. So for the sole crime of interference with a law enforcement officer, severity level 9, non-person felony with a criminal history score of A, the defendant will be sentenced to the mitigated box of 9 months. If she has to do that time, she'll be eligible for 20% good time credit and subject to 12 months of post-release supervision. Her application for probation is considered and it is granted for a period of 12 months to community corrections, given the LSIR score. I don't have, Ms. Wilson, I don't have the authority to order your supervision to be consolidated, so you only have to visit in one place. But I know that probation will do that, okay, particularly between Johnson County and Wyandotte County. You need to report here in Wyandotte County until they tell you that you can just do it in Johnson County. You understand that?
Yes, Your Honor.
All right. Part of your probation in this case is going to be that you successfully complete the residential center program in Johnson County and follow all the aftercare recommended by that program. And I know that that's a condition of your probation in Johnson County too. So I think you're going to do well. I am, as far as costs and fees go here, this is really why I'm convinced. I think that Ms. Wilson, when she gets out and gets her substance abuse under control, they're going to require her to have a job. And I am almost certain that the judge in Johnson County probably did not waive court costs, supervision fees, and things like that. So I think she'll be paying the cost of her supervision. I don't have any problem waiving that. The court docket fees, I don't think are important as well, so I'll go ahead and waive those. Mr. Richmond, I am going to waive your attorney fees as well as the bids application fee. It says the KBI database fee is required. That was probably true before her other convictions and sentences in Johnson County, but I am sure now that she is in the database, so that will not need to be assessed. There is no mandatory fine, so I will not fine her as well. Leaves her pretty much without costs or fees in this case. Not pretty much, it does. All right. So, Ms. Wilson, I have to advise you of a couple of things. As a convicted felon, it's prohibited for you to own or possess a firearm. Certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You understand that?
Yes, Your Honor.
All right. You have 14 days from today to appeal anything you don't like about your sentence, and you may be able to seek expungement after a period of time following successful completion of probation. With all of that, Mr. Relf, anything that I have not covered today? I think you guys covered the jail time credit.
Judge, I actually have 70 days calculated for the jail time credit.
Okay.
So it's just a tad bit more than what Mr. Richmond had. Other than that, I think you have covered everything.
All right, Mr. Richmond.
No, Judge, the only thing I wanted to know is, Megan, do you have the number for community corrections so I'm going to send Diamond a letter?
I am, let me make sure of this. Anything else we need on the record, then I will stop the live stream and I'll give out that number.
Nothing, Judge.
Anything else?